Okay. Sorry about that, everyone. I'm going to begin again. Good morning. My name is Veena Kumar, and I'm the moderator for this session today. Before we begin, I would like to remind our spectators that your microphone should remain off at all times. For judges and participants, please keep your cameras on, and microphones should be on mute when not speaking. Okay, session W1 of the Walker Mood Supreme Court is now in session. This is taking place in the Red Bull courtroom. It is with great honor and privilege that I present the following justices who are presiding. Please bear with me for any mispronunciations. Justice Christine Cusey, BLG. Justice Simon Clements, Steber Burlack LLP. Justice Warren Bongard, ZSA Associates. Justice Karen Hamway, Gowling. Justices of the panel, I present to you in today's matter before the court, speaking on behalf of the appellant, Ms. Armstrong, Kirsten McCann, and Ashley Murray, and speaking on behalf of the respondent, Dr. Ward, Jillian Tanzer, and Lauren Thompson. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and respondent's counsel will have 30 minutes each in total, 15 minutes allotted to each council member to present their arguments to this court, including answering questions from the bench. The appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there's 5 minutes left per speaker, and this will be the signal. Hopefully everyone can see that. Appellants, will you be using your 3-minute rebuttal?
Yes, we will.
Okay, thank you. The court now invites counsel for the appellant to begin.
Okay, so good morning, justices. My name is Ashley Murray, and my co-counsel Kirsten McCann and I are here on behalf of the appellant Karen Armstrong. As we all know, we are here today because Ms. Armstrong lost her kidney after sustaining injuries to her ureter during a laparoscopic colectomy that was performed by the respondent, Dr. Colin Ward. The question that this court must answer is whether Dr. Ward followed the standard of care that was required of him to prevent the injuries Ms. Armstrong sustained. The trial judge found that Dr. Ward breached the standard of care by bringing the ligature device within 2 millimeters of Ms. Armstrong's ureter. The majority at the Court of Appeal held that the trial judge erred by imposing an improper standard of care by conflating standard of care and causation, not considering or ruling out non-negligent causes, and concluding that Dr. Ward breached the standard of care. Our submissions will demonstrate why the trial judge made no such errors and why the appeal should be allowed. I will be dealing with the first two issues, and my co-counsel will make submissions onwards. My submissions have 2 main points. Firstly, that the trial judge correctly applied the standard of care for medical negligence in Canada to this case. And secondly, that causation can be used as circumstantial evidence to inform the standard of care. My first point starts on page 6 of our factum. Determining what a reasonable physician must have done or omitted to do in order to meet the standard of care required in a particular case must be determined by the court. In this case, the trial judge found that the standard of care required of Dr. Ward was to identify and protect the ureter and to stay at least 2 millimeters away from the ureter while the ligature device was in use. This was not controversial at trial and was supported by evidence and expert testimony. Our friends, the respondent, will submit that the trial judge found that Dr. Ward took steps that a prudent surgeon would have taken during a surgical procedure, and therefore the trial judge should not have found that Dr. Ward breached the standard of care. Respectfully, this is not true. The trial judge determined that while Dr. Ward took steps to identify and protect the ureter, he did not stay away from the ureter when using the ligature device, which was an essential step required to meet the standard of care. The majority concluded that the trial judge erred by defining the standard of care by way of a goal rather than of steps that a surgeon needed to take, therefore establishing a standard of perfection. The appellant submits that the trial judge made no error. The trial judge did not define the standard of care by way of a goal. Rather, the trial judge defined the standard of care with steps which included that a reasonable surgeon would have stayed 2 millimeters away from Ms. Armstrong's ureter. In any event, goals and steps essentially draw the same meaning. Every step could be considered a goal. One could say that removing the colon was the goal of the surgery. Identifying, protecting, and staying away from the ureter were steps that needed to be taken. Like a checklist, a surgeon has to check off each step to complete a surgery, in this case, a colectomy. Dr. Bernstein, Dr. Hagen, and Dr. Ward described that keeping the ligature away from the ureter was a step that needed to be completed by the surgeon. Therefore, the trial judge did not err. Dr. Hagen, the expert witness for Dr. Ward, confirmed that if a surgeon had properly identified and protected the ureter, you wouldn't have had this injury. In fact, Dr. Hagen had never seen a ligature-related injury to a ureter in his practice. That being said, Dr. Hagen also testified that you have to identify the ureter and take precautions to know where it is, and if you did that, it would not be a breach of the standard of care. Basically saying that trying to do such steps was sufficient to not breach the standard of care. Our friends will echo this and say that Dr. Ward took precautions and therefore did not breach the standard of care. Respectfully, if this was to be upheld, it would be very concerning, as a surgeon cannot be expected to only try to perform steps, because this could be a defense to almost anything, which would be very concerning for medical negligence cases. In dissent, Justice Van Rensburg referenced Rollins and Wright, where it was noted that there is a difference between using the appropriate technique and executing it properly, correctly stating that attempting to take steps does not equate to achieving the standard of care required of a reasonable, prudent surgeon. Dr. Ward needed to execute all steps, including staying at least 2 millimeters away from the ureter to meet the standard of care. Furthermore, there was no testimony of how staying away from the ureter might not be possible. The surgery performed by Dr. Ward was described as Surgery 101, and Ms. Armstrong's operation itself was described as an ideal setting. No witnesses said how a reasonable, prudent surgeon performing a colectomy on a structurally normal colon could take reasonable precautions and nevertheless come within 2 millimeters of the ureter. In fact, Dr. Bernstein said the risk of the injury should be zero in the circumstances of this case. And Dr. Hagen said you're really nowhere near the colon, so it's not possible to damage the ureter if you've identified and taken the vessel. In Hassan and Anarvi, the appellant surgeon was found to be negligent after performing a laparoscopic operation on the respondent and cutting their aorta. The surgeon appealed the decision on the basis that there was neither evidence of negligence nor that he breached the standard of care, and that the trial judge wrongly found him liable based only on the fact that a mistake occurred. The Ontario Court of Appeal dismissed the case in part by determining that the trial judge's findings of negligence was supported by evidence of expert witnesses and the specifics of the injury itself. The Court of Appeal found that the trial judge was entitled to make the finding as an inference from all the circumstances and made no error in doing so. The court also stated, and I quote, if it is not a function of this court to reweigh the evidence or to second guess the findings of fact made by a trial judge. The same deference is owed to the trial judge in our case, who found that Dr. Ward breached the standard of care because based on the evidence, he determined that the injury to Ms. Armstrong's ureter occurred as a result of Dr. Ward not staying sufficiently away from the ureter. The trial judge was entitled to make that finding and made no error in doing so. Now, my next point will demonstrate why causation can be used as circumstantial evidence to inform the standard of care.
I'm just going to stop you before you move on.
Yes.
So in reviewing the decision below, articulating the standard of care is a question of law. And what you've advocated is that we should treat it as a question of fact and give deference to the court below. So why do you say it's a question of fact?
So what I'm saying is that the standard of care, to define the standard of care, is based on the risk of harm that occurs, this being that the ureter was damaged. And so in order to then define the standard of care, the trial judge had to see what the steps were required to not injure the ureter. So without looking at those facts, there was no way that they could identify what steps needed to be taken without knowing that the ureter was damaged or that was where the injury was. Like, the standard of care could have been protecting the heart. Without knowing what the injury was, they couldn't have formulated what that standard of care had to be.
Isn't that the answer to your next question, which is how you use causation? Because we have to understand what happened.
It is, yes.
So going back to my question, which is, why is the standard of review giving deference to the lower court?
So it's giving deference to the lower court because there was no error here on the standard of care that the trial judge articulated and then found that Dr. Ward breached. It was fully supported by the evidence. All 5 experts said, including Dr. Ward himself, that staying away was one of the steps that was required. So then when the Court of Appeal goes on to say that wasn't what it was, and that Dr. Ward identified and protected the ureter, and therefore he didn't breach the standard of care, that was an error because the trial judge said that third step I've mentioned, that staying away from the ureter by 2 millimeters, was a step that needed to be taken. And the trial judge found that he did not, and the trial judge was entitled to make that finding.
So you're saying that each of these are findings of fact and not findings of law.
Correct.
Okay, carry on, thanks.
Okay.
I have one question before you move on, Ms.
Sure.
Murray. The reliance on Dr. Hagen's evidence that he gave evidence in the lower court to the effect that the injury could not have occurred basically but for negligence because you are not close to the colon when you are using the ligature and separating out the ureter. But is there not a place in our law in medical malpractice cases for an error in judgment? In other words, you are holding this surgeon to a standard of perfection. How do you explain the difference between that, and do you give some room for an error in judgment as a possibility in this case?
Sure. So I was going to touch on this in my next point, but at trial, there was only 2 explanations offered to the trial judge. That being that the appellant, Mr. Armstrong, submitted that the damage to the ureter occurred as a ligature device coming within 2 millimeters of the ureter. And then Dr. Ward submitted that he stayed 5 to 15 centimeters away from the ureter while nonetheless still causing the scarring. So to answer your question, I would say an error could have occurred if, and Dr. Ward could have argued that, however, he did not. So if he could have explained, oh, yes, I had an error in judgment, I came too close and it was a mistake and this is why it happened, then the trial judge would have weighed that accordingly. However, he did not submit that, and therefore she was not entitled to come up with these other explanations and error in judgment. She had to weigh those 2 options, and she found that the thermal injury supported the appellant's theory.
Thank you, counsel.
Okay, so I'll just quickly move on to my next point if there's no other questions. So dealing with the point that circumstantial evidence can be used to inform the standard of care, in some cases, like our case, it can be necessary to determine what happened to determine if the standard of care was breached. This is fully supported by jurisprudence. In Fontaine in British Columbia, it was decided by the Supreme Court that whether an inference of negligence can be drawn is highly dependent upon the circumstances of each case. In Maringlo and Oshawa General Hospital, the Ontario Court of Appeal held that to resolve the issue of negligence, determining what happened in the operating room had to be done first. It is only after that issue is examined that the issue of the respondent's alleged negligence should be considered. In Kennedy and Jackowicz, a case similar to ours, where a surgeon performed a laparoscopic surgery to remove the appellant's ovaries. During that process, the appellant's colon was burned. In this case, the trial judge stated that it may be appropriate for an expert or the court to infer from the nature of the injury what it was the surgeon did. Once having determined on all the evidence what the surgeon did, the inquiry shifts to the question of whether what was done falls below the standard of care. All of the cases mentioned support why the trial judge in our case needed and was entitled to determine what happened before he could decide whether the standard of care had been breached. As I stated, the trial judge was presented with 2 different explanations for what could have caused the blocked ureter. With these different explanations presented, it is clear the trial judge needed to first determine what happened, to decide how Ms. Armstrong's ureter was damaged, and whether that constituted a breach of the standard of care. The trial judge accepted the evidence that the thermal injury sustained showed that the ligature came within 2 millimeters of the ureter. The thermal injury was evidence of what happened, and this evidence was crucial in determining whether the standard of care was breached. The injury did not define the standard of care and informed the trial judge of what happened. Our friends will submit that causation cannot be used to inform the standard of care, and that applying a causation analysis before the standard of care is circular. Respectfully, the trial judge did not do a causation analysis for the standard of care. The trial judge did not answer the question of but-for causation before standard of care. Rather, the trial judge looked at factual causation, that being what happened, to determine how Ms. Armstrong's ureter was damaged, which was needed to inform the standard of care. In conclusion, causation, specifically determining what happened, can, and in some cases must, be used as circumstantial evidence to inform the standard of care. So subject to any questions, that concludes my submissions.
You have a couple minutes still?
Yes, we do.
Yeah. Can I just ask one question of Ms. Murray, if I may? Are you suggesting that it's always permissible to assess causation before the standard of care?
So I'm saying in certain circumstances where the nature of the injury is very relevant, that it can be necessary. That's not all cases, because in most cases, knowing what actually happened isn't possible. So normally, standard of care is done first and then causation. However, there is some circumstances, as some of the cases that I've mentioned, where it is necessary.
Thank you.
We can move on to your co-counsel if there's no other questions.
Okay, hi, hello, justices of the court. My name is Kirsten McCann, and I will be moving to our third point. Our third point will answer the question of whether Mrs. Armstrong, as the plaintiff, had the duty to rule out potential non-negligent causes of her injury. Respectfully, we submit that the plaintiff in this circumstance did not have the duty to rule out all potential and possible non-negligent causes of her injury. A plaintiff's liability theory that is one of only negligence is obliged to demonstrate on a balance of probabilities that negligence of the defendant was what caused the injury. This is not disputed, and therefore the issue here is not a confusing one. The question is also not whether Mrs. Armstrong failed to propose a reasonable theory of negligence. In fact, the evidence shows without a doubt, as demonstrated by my co-counsel, Ashley Murray, that Mrs. Armstrong put forth a theory of negligence that was supported in some way by almost every witness called to testify as an expert. Mrs. Armstrong properly negated the one non-negligent theory raised by Dr. Ward at trial, that he somehow caused the injury while staying 5 to 15 centimeters away from the ureter. The trial judge appropriately rejected this theory because no expert witness testified that it was possible for a reasonably competent surgeon staying several centimeters away from the ureter to have caused the injury. The real question here is whether the plaintiff is required to theorize on behalf of the defendant potential causes not raised at trial and not put to experts the way the Court of Appeal did when they pondered whether a lack of dexterity, for example, on the part of the surgeon, or the unexpected movements of structures during the surgery could have been potential causes. Mrs. Armstrong is not required to disprove such theories because they were not put forward by the defendant or supported by any evidence. This notion is very much supported by the majority's decision in the Supreme Court case, Snell versus Farrell, when it was determined that when relevant facts are particularly within the knowledge of the defendant, such as Dr. Ward, very little affirmative evidence will be needed to justify an inference of causation in the absence of evidence to the contrary. The implication that Mrs. Armstrong, as a plaintiff in a medical malpractice case, has a duty to rule out every possible non-negligent cause to prove her theory of negligence disregards the fact that she was unconscious at the time of the injury and negligent, and the negligence causing when negligence was causing it occurred, and disadvantages her as the party without medical expertise. Justice Van Vedsenberg, in their dissent, appropriately rejected this mischaracterization of the plaintiff's role when he wrote, "The onus on a plaintiff in a medical malpractice case is not to disprove every possible theory that might be put forward by a defendant, let alone theories that are not raised at trial, but only on appeal. The average plaintiff in a medical malpractice case is not a doctor. It is therefore unreasonable to expect the average, yes?
So are you suggesting that we should reverse the onus and put the onus on the defendant?
I'm suggesting that the onus is on the defendant. Essentially, the plaintiff has a duty to essentially prove on a balance of probabilities that their theory of negligence is relevant. And once they have done that and shown that it's a prima facie case, the onus is on the defendant to negate that. And what we are submitting is that Dr. Ward was unable to negate that. The only theory he brought forward was that he somehow caused the injury while staying 5 to 15 centimeters away. However, none of the expert witnesses were able to give evidence that that could have possibly happened. And the trial judge was in his rightful kind of place, and it was his he was allowed to essentially make that call and say that on the evidence he rejected that one theory.
Do you agree that in medical malpractice cases, the onus is still on the plaintiff to prove her case on a balance of probabilities?
Yes.
So when you said that the onus is on the defendant, how does that mesh with the onus to prove your case on the balance of probabilities?
The onus is on the plaintiff to prove her case on a balance of probabilities. However, the onus shifts to the defendant then once they have done that to negate that theory, to provide evidence that, there is another possibility.
And what case is your support for that proposition?
Fontaine versus British Columbia.
Okay, thank you.
Are there any other questions? Am I okay to move forward? Okay. Okay. We asked the question respectfully, how could one be expected to disprove a theory they, let alone any experts at the trial, did not even know existed? The trial judge determined that Dr. Ward failed to present evidence negating Mrs. Armstrong's theory of negligence. This was referred to surgery as surgery 101. It was not highly complex, but rather basic surgery to which no expert, Dr. Ward himself, could reasonably explain why the injury might have occurred while still staying 5 to 15 centimeters away from the ureter. We expect our friends to mention the importance that this injury was not one that qualified as an exceptional circumstance. While we find it problematic that the Court of Appeal likely equated the category of exceptional circumstances as one to kind of narrowly fit injuries that resemble the wrong limb being removed, for example, it was an example they gave. Whether this injury was an exceptional circumstance is really beside the point. This is because Mrs. Armstrong's theory of negligence was supported by what was arguably 4 expert witnesses, and Dr. Ward failed to rebut this theory, as demonstrated and supported by Fontaine versus British Columbia, which articulated that once the plaintiff demonstrates their theory of negligence on a balance of probabilities, the burden then shifts to the defendant to disprove it. Dr. Ward failed to negate the plaintiff's theory of negligence. However, it is not the role of the courts of appeal to theorize possible causes on behalf of him. We submit that it would be a judicial error to set in the standard of medical malpractice cases as one where judges can ponder possible explanations not raised by either party and impose on plaintiffs the responsibility to disprove their validity. I will then be moving to our 4th and final point if there are no other questions. Okay. Moving to our last point, we submit that the majority at the Court of Appeal erred in applying a correctness standard of review and should have applied a reasonable standard of review. While matters of law are reviewed on correctness, matters of mixed fact and law are reviewed on a reasonableness standard. The evidence given by the physician experts is a question of mixed fact and law because it involves the application of a legal standard, in this case, the appropriate standard of care for a physician to medical facts. Matters of mixed fact and law that invoke a reasonableness standard means appellant courts must defer to the trial judge on their interpretation of evidence. Therefore, the Court of Appeal held the trial judge to an unfair standard by applying the standard of correctness and should not have overturned the trial judge's decision because drawings of evidentiary conclusions lie within the domain of the trial judge. Allowing the application of a standard of correctness is not only in direct conflict with the idea of an autonomous and integral trial proceeding, but also ignores the expertise of trial judges as those who have extensive exposure to evidence and benefit from hearing the testimony vis-a-voice. A court of appeal can only refuse to give deference to a trial judge in this sort of circumstance if it is shown that the trial judge made a palpable or overriding error in their interpretation of the evidence or the standard of care and the standard of law. The Supreme Court case, Husin versus Nicolaisen, defines such an error in the application of a legal standard to a set of facts as one that is plainly seen and sufficient in vitiating the challenged findings of fact. My co-counsel, Ashley Murray, has already covered why the trial judge did not err in the way they articulated the standard of care. The only way to protect the ureter is to stay 2 millimeters away. This is not a goal because on the evidence, there was no other way to identify and protect the ureter, and there was no evidence it was outside Dr. Ward's ability to control staying 2 millimeters away. It was surgery 101, once again. The articulation of the standard of care was therefore not a palpable or overriding error. The trial judge made no error as well in rejecting the potential non-negligent causes for the injury because Dr. Ward's explanation was not supported by evidence. Similar to the case at hand, a trial judge in Hassan versus Anvari deemed possible non-negligent causes presented by the defendant, Dr. Anvari, to be speculative and therefore dismissible because of a lack of evidentiary support. The Court of Appeal deferred to the trial judge on this matter because he was entitled to do so on the lack of evidence for non-negligent causes. The actions taken by the trial judge in Hassan mirror the rejection of Dr. Ward's explanation due to a lack of evidence supporting them. The difference in Hassan to the facts of this case is the inappropriate refusal to defer to the trial judge. The Court of Appeal's refusal to defer to the trial judge is now in direct conflict with the Supreme Court's view on the matter in Husin versus Nicholson when they wrote, "It is not the function of this court to reweigh the evidence or to second guess the findings of fact made by a trial judge." The Court of Appeal decided, thank you, Vina. The Court of Appeal decided to give more weight to possible non-negligent theories that were not brought up at trial. Their decision to do so, however, does not indicate a palpable or overriding error on the part of the trial judge for not doing the same. This notion was supported by the Honorable Court in Salomon versus Matt Thompson when the majority wrote, "The fact that an alternative factual finding could be reached based on a different ascription of weight does not mean that a palpable or overriding error has been made. Deference should have been given to the trial judge because the appropriate standard of care that should have been applied was that of reasonableness in light of no palpable or overriding errors by the trial judge, not a standard of correctness." To conclude our submissions, we respectfully submit that this court overturn the decision made at the Court of Appeal and reinstate that made by the trial judge. The trial judge's acceptance that a reasonably competent surgeon would have stayed 2 millimeters away from the ureter was an appropriate decision because it was within the trial judge's power to make, and it was supported undoubtedly by evidence. In determining the standard of care, it was appropriate in the circumstances to use factual causation as circumstantial evidence, combining them, because no non-negligent theories of causation were brought by the defense that were supported by any evidence. The trial judge was correct to reject these theories, and Mrs. Armstrong should not bear the burden of disproving every possible cause without evidentiary support. The decision not to defer to the trial judge would create the dangerous precedent that patients in medical malpractice cases need to be even more knowledgeable on medicine than their very own doctors. Deference should be therefore given to the trial judge in accordance with the appropriate standard of review, that of reasonableness. Subject to any further conclusion or any further questions, that concludes our submission. Thank you very much.
So counsel, I take your point that you're arguing that this should be reviewed on a standard of reasonableness, but yourself and your co-counsel just made many submissions about areas of law and legal arguments and framework. So how is that not then reviewable on a standard of correctness?
So what we submitted was essentially that there were no errors, palpable or overriding errors. And in light of that, it would not be a standard of correctness because it would be reasonableness. If there are no palpable or overriding errors, we submit that if there were, then we do agree that it would be a standard of correctness. However, what we have hopefully done in our submission was attempt to show the court that there were no palpable and overriding errors made by the trial judge. If that answers your question. Thank you.
Ms. McMahon, can I ask a question as well?
Mm-hmm.
So rather than chalking up the defense's duty to prove non-negligent causes, can we not chalk this case up to a very complex surgery that requires issues or quality dexterity and complication, which can cause sometimes these types of injuries?
No, unfortunately, respectfully, we submit that that is not the case. Almost every expert witness and surgeon testified that it was surgery 101. So essentially it was extremely uncomplicated. Any reasonably competent surgeon, which is what Dr. Ward should be if he was attempting this, should have been able to do this while staying 2 millimeters away. If there was, as my co-counsel Ashley Murray kind of brought up in her previous points, if there was some other mistake, an error in judgment, that is something that Dr. Ward or his defense or anyone could have brought forward at trial. However, nobody did. No one did. It was not put to any experts. It was not theorized. This was theorized by the Court of Appeal at the Court of Appeal. And it is therefore not a palpable or overriding error that the trial judge did not theorize these on behalf of the defendant himself, nor is it an error that our client, Mrs. Armstrong, didn't do that either. That answers your question.
Yes, thank you.
Thank you.
Are there any more questions? Okay. The court now invites counsel for the respondent to begin.
Thank you and good morning. Sorry, I'm losing my voice a little bit. I have another mood. My name is Lauren Thompson, and today we will split our submissions this morning between myself and my colleague Jillian Tanzer. I'll address the standard of care claim for 15 minutes. My co-counsel Jillian will address the standard of review and non-negligent causes, and she's going to conclude our submissions. Does the panel require a recital of the facts?
No, thank you. Please proceed.
Thank you. I plan to address 3 arguments today. First, Dr. Ward was reasonably prudent during Ms. Armstrong's surgery. Second, that causation should be not used to inform standard of care. And third, that the trial judgment erred with respect to defining the standard of care. So first, Dr. Ward was reasonably prudent during Ms. Armstrong's surgery. The trial judge measured Dr. Ward's liability according to the goal a prudent surgeon would have when conducting the operation, rather than the means that a prudent surgeon would use to attain that goal. The trial judge determined Dr. Ward's negligence by inquiring whether he succeeded in not coming within 2 millimeters of Armstrong's ureter with the ligature, instead of whether Dr. Ward took the steps that a reasonably prudent surgeon would take. The judge did not find that the ligature could only be brought within 2 millimeters by a negligent act or omission. The complainant alleged today that the trial judge found Dr. Ward did not take the necessary steps. However, the trial judge did accept that Dr. Ward took all steps to identify and protect the ureter. This can be found at paragraph 109 of the trial decision, where the trial judge said, "I am satisfied that Dr. Ward took steps during the laparoscopy to identify and protect the ureter." He explained those steps and testified that he always kept at least 5 centimeters away from the ureter. Despite that finding, the judge found liability on result. The Court of Appeal majority allowed Dr. Ward's appeal and held that the trial judge erred in his analysis of the standard of care. This is because the trial judge improperly established a standard of care of perfection and erred by defining the standard of care as a goal rather than analyzing the reasonable means to be employed to achieve that goal.
Counsel, if I could just stop you for a moment. Aren't you essentially saying, as the appellant said, that trying is the standard of care, right? As long as the physician tried to get it right, then he met the standard of care. So why should we accept that, which seems like a very low bar, as the standard?
No, Justice Clements, we are not saying that it's a matter of just trying. We're saying that it's a matter of completing the steps necessary. Here, Dr. Ward did complete all necessary steps within the surgery. This was found by the trial judge. So they should have assumed liability based on whether Dr. Ward performed the operation in a manner that a reasonably prudent surgeon would have. The trial judge confirmed Dr. Ward took the required steps, and they were also confirmed by the expert who showed that Dr. Ward, had he come too close to the ureter, there would be different symptoms and results. So causation should not be used to inform the standard of care. First, the standard of care cannot be based on hindsight, result-based reasoning, or a standard of perfection. And this policy is consistent through professional liability law. The Court of Appeal judge discuss the burden on the plaintiff to raise non-negligent causes that a trial judge ought to consider before determining liability. Courts must be careful to assess doctors per the standard of care at the act and not at the time of trial. The law must consider that a medical man must possess and use the reasonable degree of learning and skill ordinarily possessed by practitioners in similar communities and in similar cases. This involves a locality rule, and physicians are not held to a standard of perfection, distinguishing errors in judgment and negligent conduct. We agree with the complainants that all evidence before this trial is circumstantial. It is so circumstantial that the complainant conceded there were multiple possible ways this injury could have occurred. There's a difference between having a surgery go wrong and holding a physician professionally found negligent. And the standard of perfection is throughout this trial because it asks that surgeons not only take the steps to protect the ureter, but also execute it perfectly. There is never a zero risk surgery, and there's never a perfect patient. There's also no burden of proof on a defendant to prove their innocence. But the trial judge did find that Dr. Ward took all reasonable steps and still came within 2 millimeters of the ureter. As mentioned, this policy is consistent through professional liability law. While the impact to the plaintiff is immense, not every act that creates a risk constitutes negligence when an injury occurs, and not every act that creates risk has such severe, has such negligent implications. Surgery has inherent risks. Conduct is only negligent if deemed objectively unreasonable. First, the defendant must be the factual cause of the plaintiff's loss, which involves determining whether the injuries would have occurred but for the defendant's negligence. And second, the defendant must have been the legal cause of the plaintiff's injuries. So a health practitioner must not only demonstrate a reasonable level of care, but the Supreme Court of Canada says that an error in judgment has long been distinguished from carelessness, unskillfulness, or a lack of knowledge. The honest and intelligent exercise of judgment has long been recognized as satisfying professional obligations.
If I may just ask you to consider this and advise us of your position. It was open to Dr. Ward through his experts or through himself as an expert in his field to provide explanations as to how he could have followed the steps that were required and yet be so close to the ureter that he caused the thermal injury. So was the trial judge not entitled to assume that having had the opportunity to provide the non-negligent explanations and having failed to do so, that there were in fact no non-negligent explanations available to the defense? Given that this is an adversarial process and the burden of evidence does shift from party to party as opposed to the burden of proof. How do you explain that?
Yes, Justice Hanley. We believe that the burden doesn't shift. It is still up to the complainant to make their case. And second, regarding the fact that there was no experts, there was. In fact, the experts that the trial judge used in determining whether or not the Dr. Ward went too close to the ureter was in fact experts that weren't even in that surgical field. The first expert, while doing the same type of procedures, doesn't do laparoscopic procedures, which is and has been admittedly a completely different surgery. The second was a urologist that also has not done this surgery, does not complete the surgery, and is largely a professor. The expert that Dr. Ward submitted did in fact say that there were other ways that this could have occurred. And in fact, that if the injury had occurred the way the trial judge is stating, that you would have completely different symptoms. There would have been incontinence right after the surgery, not 10 weeks later, and that the scarring would be completely different. So I guess going back, like a health practitioner need only demonstrate a reasonable level of care. And this is different than an error in judgment from carelessness or unskillfulness. And the problem with using causation as a standard of care is that causation can be found in almost any med mal case. As the defendant was the direct cause of the plaintiff's injuries, using this to inform standard of care would create a reverse onus on defendants to prove they're not guilty in a court of law against accusations of patients. So similarly, in Resurface Corp and Hankey, the court found that while a material contribution to risk has been used rarely, the but-for test is necessary. Applying a causation analysis before standard of care is circular logic, as a defendant's conduct would be exposing a plaintiff to a risk that the defendant is duty-bound not to expose the plaintiff to. Any injury sustained by the plaintiff from the breach would be compensable. So whether the breach of duty actually caused the plaintiff's injury would never even be addressed. Thank you, Vina. In other words, in medical malpractice, creating a reversal would mean it would be up to the defendant to show that an injury occurred in any other way that the area of risk to escape the burden. The complainant's addition of Kennedy held that the court may infer from the nature of facts, and the case so far where the burden of proof were reversed were only in extreme cases with undisputed facts. Here, the trial judge had not one but two explanations of the possibility of how the event occurred, and the expert evidence that the trial judge weighed was from an expert that doesn't conduct these surgeries. Considering the principle of fairness to the defendant is similar to the Supreme Court of Canada's notion that the fairness to the plaintiff requires a principled approach of causation. The court has lowered the standard of test where it would offend the basic notions of fairness and justice, but to deny liability by applying a but-for approach. So, however, applying a material increase in risk approach to causation would result in similar injustice to defendant who may have injured the plaintiff by assessing the risk of injury. Thus, a principled approach to standard of care of causation must be and has consistently been maintained by the courts, and causation cannot be used to inform the standard of care. Third, the trial judge erred in defining the standard of care. The Court of Appeal correctly identified the judge's error. As per the Court of Appeal, the trial judge applied an improper standard of care that would have held the surgeon to a standard of perfection. Rather than focusing on the goal of the operation, the trial judge should have focused on the means used by the surgeon. The surgeon took precautions to avoid injury to the patient, and it was not proven that his actions were in fact deficient. In fact, the trial judge acknowledged the surgeon had acted with reasonable prudence. Without evidence of a breach of standard of care, the finding of liability could not stand and the actions would be dismissed against the surgeon. In this case, deployment within 2 millimeters of the ureter was the goal or the result to be pursued. The trial judge accepted that Dr. Ward took the steps necessary to protect the ureter, and despite that finding, the trial judge predicated that liability on result, and this was an error of law. Having found that Dr. Ward took the steps that a prudent surgeon would take during the surgical procedure, the judge should have focused on whether it was proof that Dr. Ward breached the standard of care. Had the judge properly conceived the standard of care, it would not have been necessary for him to have conflated causation and the standard of care decisions. The error was inextricably linked to the judicial outcome. So thus, first, Dr. Ward was reasonably prudent during Ms. Armstrong's surgery. Second, causation should not be used to inform the standard of care. And third, the trial judgment erred with respect to defining the standard of care. This does conclude my submissions. Pending any further questions, I would like to pass my submissions to Jillian Tanzer, who will address the standard of review, non-negligent causes, and conclude our submissions.
Ms. Thompson, one quick question before we move on to your co-counsel. Are you suggesting that it is never permissible to assess causation before the standard of care?
Absolutely not, Justice Bongard. The reason for this is it can be based on the facts. Like, this is a factual context. Here, there is no overriding facts to demonstrate negligence. Had Mr. Ward been not prudent, or had he missed several of the steps, then this would be a different case. Thus, the facts in this case just simply don't equate for the reversed burden.
Okay, thank you.
Thank you.
Sorry. Thank you and good morning, Justices. My name is Jillian Tanzer. As my colleague has mentioned, I will be addressing the issue of the obligation of the trial judge to rule out non-negligent causes. This refers to the Court of Appeals majority decision in paragraphs 46 to 58. And time permitting, I will touch on the Court of Appeal use of the standard of correctness. It is our position on behalf of Dr. Ward that the Court of Appeal correctly identified the circumstances in which it is appropriate for a trial judge to rely solely on injury to define the standard of care. Further, in order to do so, a trial judge ought to consider and rule out non-negligent causes. The analysis I will take you through only arises if you accept that the trial judge erred in defining the standard of care in terms of injury. If you are not convinced that the trial judge made such an error, then this analysis simply does not apply. It is our submission that the majority Court of Appeal did not create nor overturn existing law. Instead, the majority sought to clarify the narrow circumstances in which it is permissible for a trial judge to define the standard of care based on injury. As mentioned in paragraph 42 of the reasons of the Court of Appeal, the general rule is that it is an error of law to use outcomes or goals as the standard of care. Further, negligent standards of care are to be measured by the behavior that a reasonable, prudent person would undertake, rather than the results that a prudent person would seek to attain or to avoid. The Court of Appeal goes on in paragraph 46 to say that this is simply a general rule, and therefore there are limited exceptions where injury alone can define the standard of care. In paragraph 46, the court explains, and I quote, "I've described the bar on defining standards of care according to goals or results as a general rule because I would not rule out that there are cases where negligence alone could prevent a goal from being achieved or a positive result from being attained." The majority then goes on to provide two examples of the limited exceptions to the general rule. First, that of leaving a sponge in the patient during surgery, and second, operating on the wrong limb. These are clear examples where evidence could show that it is only through negligence that the outcome could happen. The difference between those cases and the one in front of us today is that the means for preventing that type of injury in the examples I had just mentioned are very well established, and therefore it would be harmless to define the standard of care as goals or outcomes instead of prudent means or behaviors. For example, it would be acceptable to find a breach of standard of care by leaving a tool in the patient or removing the wrong limb. As the majority stated, the surgery in question was highly complex and involved multiple specific steps. This, therefore, is reason to differentiate this case from the examples mentioned earlier. Therefore, it is
I'm just going to stop you there, because isn't there plenty of evidence that this is surgery 101? And so this shouldn't be any different from removing the wrong leg.
In our position that there's multiple steps that needed to be taken in order to perform this surgery, and you need to identify and protect, and you need to continue to re-identify and protect. So while not maybe the standard one, the rule 101 refers to not injuring the ureter, risk comes in any surgery, and this surgery definitely had risk, which was found. But at the end of the day, Dr. Ward did take all steps as found by the trial judge. So we're just saying that this involved multiple specific steps that needed to be taken that Dr. Ward had taken. So that's how we would differentiate this case from the examples I had mentioned.
Well, let's take the cutting off the wrong leg example, right? You know, there's a surgical checklist that every surgeon has to go through before performing a surgery. And it involves like 19 steps of identifying the patient, identifying the limb, you know, making sure that you've got, you know, the right equipment, all of that. And on the 19th step, equivalent to not going within a millimeter of the ureter, the surgeon cuts off the wrong leg. So why is it different? Why is it different when, you know, we're talking about a millimeter versus we're talking about a limb? But theoretically, conceptually, going through the steps is exactly the same.
So in response to that, I would say that the trial judge did find that he took all the steps that were needed in this case. So that's our main point. But I just also want to say that to avoid injury in the case, such as taking off the limb, that's very, very well established. Whereas here, like I said, it's established that you need to identify and protect, and it was established that he did so. So that's what I would say to that.
So are you suggesting that we can only find negligence in well-established situations?
No, what I'm saying is that in this case, where a plaintiff is saying that negligence, like that the injury arose and therefore there is negligence, such as cutting off the wrong limb, those are cases where a plaintiff ought to bring evidence to prove that claim. We can't just assume that there is negligence. A court needs to be satisfied that only negligence could have caused this injury. So as the majority stated, the surgery in question was highly complex and involved multiple specific steps. This therefore is reason to differentiate this case from the examples I just mentioned. And therefore, it is our position that it is highly unlikely that this case would fit within the limited exceptions to the general rule. And therefore, injury alone cannot define the standard of care. If, however, the court was to find that it does fit within the narrow exceptions, the plaintiff failed at discharging their burden as they did not bring forward any non-negligent causes. Therefore, in this case, the plaintiff at trial simply did not provide enough evidence, and therefore the trial judge was left with insufficient evidence to rule out non-negligent causes. In response to the appellate's factum at paragraph 37, it is our submission that we are not suggesting that the trial judge needs to go outside of the case, do their own research, make their own speculations in order to rule out non-negligent causes. Instead, in line with making their case, if a plaintiff wants to lead the case that only negligence can cause the injury, then a plaintiff ought to provide such evidence. This does not create nor increase the burden placed upon the plaintiff. It is always open for the plaintiff to pinpoint a negligent act or omission through expert evidence or otherwise. If we do not rule out non-negligent causes, then we are simply defining the standard of care through strict liability. Essentially, if you come within 1 to 2 milliliters, you will be liable. And if the court is willing to accept that, it must be satisfied that this could only occur through negligence and no other possible causes. This is something that the trial judge ought to have made a finding of through the plaintiff's evidence. It is our submission that there was insufficient evidence for the trial judge to make a conclusion that in every case there is negligence by coming within 1 to 2 milliliters of the ureter. Further, there was no evidence that it could only be by virtue of negligence that you come within 1 to 2 milliliters. To conclude on this point, an injury alone will not prove negligence unless in exceptional circumstances that are analogous to the examples I had just mentioned. This case does not fall under those exceptional circumstances. However, it would have been up to the plaintiff to demonstrate that their case does fall within that category, but the plaintiff ultimately failed to do so. Oh, I can hear you.
Sorry to interrupt you. I just had a question. You were saying that the trial judge was saying that they didn't establish that in every case, but aren't we only concerned with this case? And isn't negligence assessed on a case-by-case basis? So we can't generalize as to what is negligence in one case will necessarily equate to what is negligence in this case?
Yes, I agree with the general point. However, in this case, because it was based on injury. It sets the standard that if there's an injury to the ureter, you must have come between 1 to 2 milliliters. So that does set a standard, such as cutting off the wrong limb. It puts it into that category, which we are arguing that they are different and that they shouldn't be in the same category. So
Ms.
as a
Tanzer,
result,
sorry to interrupt you, Ms. Tanzer. Is there a scenario in which there is an obligation of the defendant to have proved non-negligent causes, in your opinion?
well, we don't think that that burden should shift onto the defendant. That would reverse the burden. So it's our opinion that, thank you, that if you're going to make the case that only negligence could cause this injury, then you ought to provide such evidence. And if you don't do so, then it's hard to, it could have been other theories like that are non-negligent. So It is our position that if you do not provide such evidence, then you are not, then you're almost making strict liability claim, and that shouldn't be the case here.
Okay.
So as a result, it was an error for the trial judge to find negligence without sufficient evidence that would rule out non-negligent causes. Now to quickly shift gears to the standard of review, it is uncontentious that the appellate standard of review for questions of law is that of correctness, and the standard of review for questions of mixed fact and law is palpable and overriding error. A finding of negligence is typically a question of mixed fact and law, and therefore the standard will be on a spectrum. However, where there is an error to a finding of negligence that is attributed to the application of an incorrect standard or a similar error, this error will be characterized as an error of law and therefore subject to the standard of correctness. The Court of Appeal attributed the error of the trial judge to the incorrect definition and application of the standard of care, and therefore this is characterized as an error of law and subject to standard of correctness. Therefore, the Court of Appeal made no error in applying the standard of review of correctness. And that concludes my submissions. Pending any other questions, I do thank this court for its time and questions.
There are no other questions, just confirming. Okay. The court now invites counsel for the appellant to begin their optional 3-minute rebuttal.
Okay, we just want to say thank you once again to all the justices and to our friends, the respondents. We want to begin with what the Supreme Court said in Fontaine, that being that the trier of fact should weigh the circumstantial evidence with the direct evidence, if any, to determine whether the plaintiff has established on a balance of probabilities and prima facie case of negligence against the defendant. Once the plaintiff has done so, the defendant must present evidence negating that of the plaintiff, or necessarily the plaintiff will succeed. This is what occurred in this case and is why Ms. Armstrong should succeed in this case. The respondent submitted that the trial judge found that Dr. Ward took all the steps because in paragraph 109 of the Court of Appeal document, the trial judge stated that Dr. Ward took steps to identify and protect the ureter. This is true. However, they failed to mention that the trial judge went on to say in paragraph 110 that he did not accept that Dr. Ward stayed sufficiently away. Our friends submit that staying 2 millimeters away from the ureter is a goal that should not have been included in the standard of care. Respectfully, that would leave a surgeon to ask what must be done to identify and protect the ureter. This would be very ambiguous. Staying 2 millimeters away needed to be part of the standard of care to know what needed to be done. Our friends submitted that physicians are not held to a standard of perfection, and that as long as the physician exercised reasonable care when making the error of judgment, there will be no negligence. We want to reiterate that this is true. And if Dr. Ward had explained that he came within 2 millimeters of the ureter, but had done so by simply making a mistake or error in judgment, the trial judge would have weighed that evidence accordingly, but he did not. He only offered that he stayed 5 to 15 centimeters away, which was rejected based on evidence of the injury occurred because of thermal spread. Our friends mentioned the importance that this injury was not one that qualified as exceptional circumstances. While we find it problematic to equate the category of exceptional circumstances so narrowly as to only fit injuries that resemble the wrong limb being removed, whether this injury was an exceptional circumstance is besides the point. This is because Ms. Armstrong's theory of negligence was supported by what was arguably 4 expert witnesses, and Dr. Ward failed to rebut this theory. As supported in Fontaine, which articulated that once the plaintiff demonstrates their theory of negligence on a balance of probabilities, the burden shifts to the defendant to disprove it, and this was not done. So to conclude, we ask that this court upholds the trial judge and sides with the plaintiff. Thank you.
Okay. This concludes the matter of Armstrong and Ward. Thank you, everyone. Could I, just as a reminder, ask all the judges to send their factum score sheets in as per the instructions you would have received? I will be stopping the recording shortly, and I invite everyone to remain for the next session. This Zoom session will remain open, and the next session begins at 10 a.m. Thank you all very much.
Thank you all very much.
Thank
Thank
you.
you.
Thank you. Thank you,
Thank you.
counsel. Ably argued.